sounds and smells as source identifiers. So I'm sure many of you are familiar with the NBC chimes. You've probably heard this. This sound was first used in 1961, and it was originally used so radio listeners would know when an NBC program ended. Consumers hear the musical notes, G, E, and C, and associate that with NBC. NBC Universal Media LLC owns that sound. Another example is a scent. So a retail chain, Flip Flop Shops, has trademarked the coconut smell that they pump into their stores. Consumers are greeted by the sweet scent of coconut suntan oil. Owners believe that the smell is an important part of branding because the beachy aroma is a perfect fit for the brand's laid-back vibe and free your toes motto.
And this is an important issue here because what has happened in this instance is that this is part of an overall branding strategy. Branding strategies and brands are two different things. In this instance, the owner of this mark is intending to give the appearance of beach and sun and sand. It's a lifestyle strategy that goes along with their lifestyle mark, and they seem to be implementing it very well.
Yes. Okay, let's talk a little bit about the strength of a mark. Trademarks are categorized on a continuum from generic, which can never gain protection, to fanciful or arbitrary, which is inherently distinctive and therefore protectable. Generic marks, such as the common name of a product, can never gain trademark protection, as we just said, such as denim pants. What is generic depends on many factors, including culture and location. So, for example, in Australia and New Zealand, UGG is a generic term for a sheepskin boot, while in the United States, it would likely be considered a fanciful term and therefore protected. As the Eighth Circuit recognized in Anheuser-Busch versus Stroh Brewery Company, a term may be generic in one country and suggestive in another. A mark is descriptive if it provides information about attributes of the product or service, or describes the product or service itself. Purely descriptive marks cannot obtain trademark protection unless they are capable of acquiring distinctiveness by such continuous and exclusive use that consumers come to think of it as a distinct source identifier separate and apart from the mere descriptiveness of the words. So, for example, American Apparel for clothing. Moving on to suggestive marks like Top Man for clothing for men. Suggestive marks require a consumer to make an imaginative leap from the mark to the type of goods and services. And finally, moving on to fanciful marks like Lululemon for yoga apparel. This is a made-up word. Arbitrary marks like Express for clothing are generally actual words that are used in an unexpected context. And another example would be Apple for computers. Trademarks must be sufficiently distinctive so that consumers can identify one brand over another. The same mark can be sufficiently distinctive to act as a source identifier for certain goods while completely descriptive or even generic for other types of goods. And we have an example here in front of you. Polo Sport, which is owned by Polo Ralph Lauren. The word polo is not descriptive of the recited clothing. However, the word sport is likely descriptive because it provides information about attributes of the goods, clothing that would be used while playing a sport. Polo Ralph Lauren disclaimed the word sport from the mark for this reason. This means that while sport is still technically part of the registration, the owner has no exclusive rights to it because it is descriptive. So you can compare that with polo sport and the definition, which is equestrian games, polo games. This is wholly descriptive or even generic. This mark likely could not be registered at all. Personal names as trademarks, and I'm sure a lot of you in the audience are familiar with a lot of designers using their own names for their fashion lines. Personal names generally cannot be trademarked unless consumers associate the name with particular goods or services. For example, Michael Kors. The use of personal names as source identifiers is especially prominent in the fashion industry, where marks are often the name of a particular designer. And some other examples I'm sure that you'll recognize are Calvin Klein or Ralph Lauren. In order to be trademarked, sufficient advertising and marketing must be done so that the name becomes associated with the brand. If the designer leaves the firm, that designer may not have full rights to use his or her own name. So designers should be careful to negotiate their rights to their name with their fashion companies.
And that can't be emphasized enough. It has happened in the past where a hugely famous designer has left a company that he or her may have established to start a new enterprise, a new iteration of their company, a new business, and not been able to use their own name in the designs that they're now engaged in. And this needs to be considered when drafting the initial corporate documents as to who retains control over a person's name, because it's so closely associated with the design and the brand. Another issue that Maria touched on, is that the noteworthiness of a name does not necessarily need to come from advertising or marketing. It can simply be the person becomes noteworthy and therefore their name gains a certain amount of fame, like the Kardashians. Their name became noteworthy not necessarily because of advertising or marketing, but because of other issues that they were involved in. And then they developed a brand and now are marketing and advertising that.
It's a great example. Okay, let's talk about trade dress. Trade dress protects a product's design or particular attributes. It applies only to aesthetic rather than functional attributes. And it's often difficult to identify when the design of a product itself is functioning as a source identifier, which brings us to our question here. Is there protection for specific color on the sole of a shoe? Some of you may recognize the shoe as a Christian Louboutin. And we're going to talk about a case involving Christian Louboutin out of the Second Circuit of New York. Louboutin versus Yves Saint Laurent. Louboutin had marketed a shoe with a distinct color, the lacquered Chinese red that you see on the outsole of the shoe. YSL made a shoe with a similar color, but instead of having a contrasting color, the entire shoe was red. Louboutin claimed that the YSL shoe infringed its trademark rights to use of the distinct red on the sole of the shoe. The district court agreed and denied a motion for preliminary injunction. The court agreed that color in the fashion industry is an important expressive element, and one cannot compete in the industry if firms have asserted the exclusive right to specific colors. The Court of Appeals came up with a different solution, which is quite clever, actually. The question presented to the Second Circuit was whether a single color may serve as a legally protected trademark in the fashion industry, and, in particular, as the mark for a particular style of high fashion women's footwear. Christian Louboutin has been painting the outsoles of his shoes this red lacquer color, his high-heeled shoes, since 1992. He registered the red lacquered outsole as a trademark with the U.S. Patent Office in 2008. Having this information, the Second Circuit disagreed with the district court and determined that it was error to determine that a single color can never serve as a trademark in the fashion industry. The trademark of the red sole had acquired limited secondary meaning as a distinctive symbol that identifies the Louboutin brand. The court did not address whether YSL's use of the red outsole risks consumer confusion or whether the Louboutin mark, as modified, is functional. But the ultimate conclusion is that there was limited trademark protection for this red Louboutin color, so that it only protected contrasting colors between the sole of the shoe and the rest of the shoe. So YSL shoes was not a problem.
And one thing that Maria also focused on here was it's not necessarily just colors. Shapes are important as well. One of the prime examples of a shape gaining secondary meaning is obviously a Coca-Cola bottle, where if everybody sees that historic shape of a Coca-Cola bottle, you know it's Coca-Cola. So when developing a brand strategy, consider shapes and colors and what image you want to portray for that product or brand. Focus on consistency in shape and colors. Focus on uniqueness and focus on protecting those identifiers that are part of the brand strategy when you're formulating that brand strategy.